do so. There was a lot of debate, there was a lot of wonder whether the Supreme Court would take the issue. It did take the issue, which means it has called the question on whether the rule it suggested in South Dakota versus Dole, which is there could be some restriction on federal money that is so coercive that it would violate the Constitution. They have now called the question on that, and I think they will decide it. And I think, frankly, they will either have to abandon that doctrine, or they will have to rule that this violates it, because there is no other imaginable case that could be more clearly coercive. Indeed, it's interesting, if you talk to state officials, as Bill was, but especially in the healthcare area that will actually have to administer these programs in private about these issues, there is fear in their eyes. This will involve humongous costs that they know they can't meet, and no one believes that the federal government will continue over the long term to fund this. As a result, this is a critical issue for them. They cannot withdraw from Medicaid. Indeed, there is actually no provision in the law permitting it. I mean, we all assume that, well, there must be some way that a state can withdraw. Frankly, if you look at the statutes, there's no mechanism for that. Presumably, we'll have to make it up as they go along if some state were to try to exercise it. But the fact is, Congress never imagined that they would. And the way we know that in a crystal clear fashion is that if a state withdraws from Medicaid, then the poorest people in that state have no means of complying with the mandate. Congress provided a means for not the poorest, but a certain tranche of people who are above the poverty line but still not affluent. They expanded Medicaid to cover those people so that they would be able to comply with the mandate. And if they don't, if the states do not do that, then there are a federal alternative that will still cover them. There's no alternative for people below the poverty line. Basically, we either have to accept that Congress didn't care about that and that it really didn't care about universal coverage, or that it never imagined any of the states could withdraw. This law is mandatory, and it is extremely coercive. Very briefly, with respect to the Anti-Injunction Act, as Bill mentioned, that I do not think that is going to be the court's going to take very much time in getting past it. It doesn't apply to the states. There's a case, South Carolina against Regan, that establishes that. And it's not a tax. The individual mandate has no, it is not based on Congress's taxing authority, it doesn't raise revenue, it's not in the language that a tax is ordinarily passed in. It's a mandate, and it's enforced by a penalty. The only tax aspect of this law, or this provision of the law, is that it is housed in the Internal Revenue Code. And that, because the way it will be enforced is that the IRS will keep your income tax refund if you don't comply. That's how they will collect it. Otherwise, there is no aspect of the mandate that is in any sense a tax. Let me actually stop there, and we can get to the questions.
Thank you. You know, if I could make a quick point on, Judicial Watch cares about corruption. I think some of the intersections here are worth discussing or highlighting. One is the issue of severability. If this legislation had been treated in the normal course of things, the House and the Senate would have figured this out. But they had to get it passed the way they needed to get it passed. They knew or should have known the severability issue would have popped up, meaning if the individual mandate was thrown out, would the whole kit and caboodle go out with it? An effective, I'm sure you have something to say about this bill. There are enough people in Congress with enough experience to know how to pass legislation that would survive a severability challenge. And the fact that it didn't is not an indication that the law was badly written, that it was just that the process was screwed up in getting it passed.
Well, certainly they had an enormous task in writing this, and they were passing it with the 60 votes they had to find over in the Senate, and they had devious ways of doing it, and it was a mess. I wasn't here for that, but I've heard stories about it, and I'm sure they omitted the severability clause. It may have been by accident. I doubt it was intentional, but on the other hand, the fact is they did not put it in there, and that gives us a big opening, and it gives us the chance to make the argument, which is sensible. The argument being that why would they have passed this without the individual man? How are they going to pay for it? They could have passed a tax, a regular tax. They could have said, okay, we're going to increase the income taxes and pay for this. Or they could have done what some conservative groups have argued since, but has not yet been promoted in legislation, and that's a refundable tax credit, which would be another way, again, for the federal government to subsidize, but it wouldn't be mandating something under the Commerce Clause. It wouldn't be violating what Lee has just talked about and going into an area that is beyond the enumerated powers, in our view, in the Constitution, stretching the Commerce Clause to a ridiculous extreme and taking you into the requirement to buy a product or a service for the first time. So I think they messed up, but I'm not sure. They knew all of this. The briefings they got from Congressional Budget Office and Congressional Research Service and everybody else told them everything, but they weren't going into this without being aware there were potential constitutional issues here.
I don't ask this question to put anyone on the spot with regard to presidential politics, but it's a matter of public debate as to why it is a state like Massachusetts could require individuals to purchase health care but not the federal government. Lee, could you speak to what the constitutional differences might be, or maybe
Sure.
Massachusetts isn't able to do that under the law?
Well, I mean, I think it is, because it is a state and it has a police power. I mean, requiring you to get health insurance or car insurance or even life insurance is certainly, at least I think, within the state's general health and welfare powers. But it's only the states that have that, and obviously Massachusetts did adopt such a provision. Some of the other states may have considered it, but there's no problem. There's certainly no legal or constitutional problem with them doing that. And I think that really highlights the fundamental issue at stake here, which is, are we going to dissolve or eliminate the bright line between what kind of powers the federal government can exercise and what kind of powers the state can exercise?
Betsy, the constitutional concerns aside, the practical concerns, I think, deserve a lot more attention here in Washington, and the transformation of our healthcare system that's taking place as we speak. Could you address that a little bit? I know you work closely with the healthcare industry and have a lot of expertise there about what's happening now in response to Obamacare that Americans ought to be concerned about.
Well, let me focus on one issue regarding that question that I think everyone in the room will care a lot about, and that is the rapid diminution in the ability of doctors to make the best decisions for their patients, unencumbered by federal interference. And that's why when I made my brief remarks at the beginning, I focused on Section 1311 of this law, because you're not simply required to be enrolled in what's called a qualified plan, a plan that meets the requirements for essential benefits as defined by the federal government, by members of the executive branch. But once you're in that qualified plan, this law gives the federal government a lot of authority over your health care, even though you're paying for the plan yourself. And beginning with the stimulus law, which you mentioned earlier, the architecture for real controls over how doctors treat privately insured patients are being put into place. The stimulus law provided very large payments to doctors and hospitals to bring on board the kind of electronic health information technology needed to create a system of electronic medical records. And even leaving aside the privacy issues for a moment, the rationale articulated by members of the administration, David Blumenthal, Ezekiel Emanuel, the doctors who were advising the president, was that we really can't rely on doctors to do the best for their patients. There have to be federal guidelines to direct how doctors treat patients with an eye toward reducing the amount of care used. And we should all be concerned about that because, as you mentioned earlier, Of course, it's very important that we're going to court to protect the bright line between state and federal authority and to protect individual rights from an overreaching federal government. But in addition, we're trying to protect the best health care system in the world. We all want everyone to get enough health care and to have access to health insurance. But just look at the data. If you're a seriously ill person, the best place to be is in the United States. A woman with breast cancer here in the U.S. has over a 90% chance of surviving it. In Europe, her chances are less than 80%. If you do the arithmetic, that means she's twice as likely to die from that diagnosis. Or if you take prostate cancer, a man diagnosed with prostate cancer here in the U.S. has a 99% chance of surviving it. It's not a death sentence here. But in Europe, nearly 1 out of every 4 men who gets prostate cancer dies from it. So we really have to make sure that the elements of this law that not only require you to be an insurance plan, but in an insurance plan that's highly regulated by the federal government, where the regulations go beyond what the insurers do to what the hospitals and doctors being paid by those insurers do, that is really dangerous for the quality of your health care. And of course, as you mentioned, the healthcare industry, it's already having a very detrimental effect on research because people are looking ahead to see, well, what kinds of diagnostic tests and therapies will doctors and hospitals be free to use under Medicare, the largest payer to hospitals, but also even under the commercial insurers. And I will just leave you with one statistic. Since 1950, the United States has won more Nobel Prizes in medicine and physiology than the entire rest of the world combined. If you have a serious illness that's considered incurable, this is the place to be. This is the place where there's hope, right? So we want to make sure that whatever changes are made in our healthcare system to increase access and affordability, do not do it at the expense of the quality of care and the independent ability of doctors and other caregivers to make clinical decisions for their patients without having their arms pulled back and tied by the federal government.
May I piggyback on that, Tom? I think Betsy's got exactly the right scope on this, but I want to point out what I think is the heart of the problem, the overriding heart, and that's the idea that the federal government centrally is going to be able to control all of the costs. And you have to realize that there's philosophical driving forces. There are philosophical driving forces here that want to go towards universal coverage, single-payer system, blah, blah, blah. Some of them are unwitting. Some of them are very witting. But when you get the train moving, what puts all these interest groups and everybody else into the train with them on a lot of this is the idea we're going to say we got to solve the problem of rising health care costs. To who? Who's paying this? The taxpayers. So if the government keeps getting bigger and bigger at the federal level, the pressure keeps getting greater and greater because of budgetary reasons to reduce the availability and access to certain care. I mean, how else can you put it? Rationing done by the government for various reasons. The pressure in this bill to consolidate, to get doctors to go and go to work for hospitals. The idea of pressing hospitals and other healthcare providers to consolidate, to take as much. I mean, all of it's designed to save money, they say, but for whom? Save money for the federal government. And that's what's so bad about this. The federal government is therefore planning all of this in the name of doing good, but really the driving force is all about money. And what gets lost in it, too, is what she's pointing out, and that is the accessibility and the quality. Because if you see this system as I'm seeing it now, you're having fewer and fewer doctors per number of patients. As the number of senior citizens and the baby boomers retire, as you see doctors retire, as you see problems that we have getting young people to go into specialties, as you see that there are not enough residencies, and we may need more. There are a lot of articles recently that I've read, I'm sure you have, that we aren't getting enough graduates, new graduates out of medical schools. Well, they're not anywhere near the number of residencies in the hospitals to be able to get these people trained right now. So we're already behind the curve. This makes it far worse. So when you talk about accessibility to what kind of health care? And are you going to have enough people who are nurses or physician's assistants to make up all of it? There are people out there who believe that. Well, that's the way to go. And they can do some of it, but they can't do all of it. And they can't make up for the doctor in every case. So that causes quality to go down, causes accessibility to go down for what it presently exists. And when they talk about accessibility, I think they're talking, the other side, about insurance coverage. And that's not true. Anybody can go get a doctor, but it's the emergency room and the whole thing that the hospitals don't like about cost shifting, which is, is part of the argument in the lawsuit. But it's a very big picture argument. People get lost in the weeds. They don't want to read all this stuff. It is complex in that regard. It is, Betsy. But when you have to read the 2,700 pages, you have to spend the time the three of us have looking at not just the law but the whole thing. The picture becomes pretty clear, and you just cry out inside you to somehow tell the world what this really is all about, and that there are alternatives to this that provide for pre-existing condition to be covered or provide for more people to get better access. But this is not the way to do it.
Well,
this is unrelated to the constitutional issue.
And frankly, you don't need to read the whole thing. If you just listen to what the Attorney General is saying, and when you read newspaper articles about agencies or medical boards suggesting that certain drug treatments are not cost effective, or don't work, comparative effective research. One drug decision they made as they were considering at the Medicare level, I forget which drug it was, John Alton, if you remember, if you can hear me. Well, anyway, they're not supposed to consider cost. And it's an expensive treatment. But you see it pop up in the email traffic. We uncovered the documents. So it's clear that cost is a driving factor in these decisions that you're hearing, well, don't do this treatment, don't get mammograms before a certain age, don't get this prostate cancer drug, don't get this breast cancer drug. The benefit is not worth the cost. And that's not a medical decision, that's a political decision.
Right. I wanted to point out the one quote from Kathleen Sebelius that embodies this very dangerous fallacy. Here she is, quote, "The only way to slow Medicare spending is to slow overall health care spending through comprehensive and carefully crafted legislation," like this, right? Now, of course, there are other ways to slow Medicare spending. We could inch up the eligibility age. We could ask some seniors who have the means to pay larger copays or pay a larger premium to share the cost. Instead, what the government has done is decide to lower the standard of care for all Americans. And when you look at what this law does, the share of health care paid for by the federal government is actually increased from 45% to 50% over a short period of time, just a few years by 2020. As Medicaid spending soars, Medicare spending, of course, is cut. There's a big shift of resources from the elderly to the poor in this law. But the key here is that there are ways to make Medicare affordable without lowering the standard of care. And what those enormous cuts in Medicare payments to hospitals, to which I referred earlier, the ones that Richard Foster, who works for the president, has warned Congress will be deadly. Those severe cuts in what hospitals are paid to care for the elderly will impose an overall regimen of scarcity in hospitals. It will mean fewer nurses on the floor, fewer pieces of diagnostic equipment, so you wait longer when you need an X-ray or an MRI, fewer cleaners. I know that means more hospital infections. And so consequently, we have to tell the people in the federal government, yes, we're concerned about the cost of entitlements, but there are ways to fix them without silently and deceptively lowering the standard of care for all Americans, which is what you just described again with the emphasis on reducing preventive services and diagnostic tests.
Lee, if you could answer a constitutional, the new constitutional argument coming out of the Obama administration. I saw Dr. Ezekiel Emanuel, who's the White House health advisor and constitutional scholar now, talking about this morning the necessary and proper clause. They're kind of avoiding the Commerce Clause and talking about this this other area related to.
Sure.
This is part of the necessary and proper
clause.
method.
Well, as I think it was Justice Scalia who wrote that you know the necessary and proper clause is the last bastion of those defending unconstitutional laws. the necessary and proper clause is exactly what it says. It allows Congress to make any law necessary and proper to carry out one or more of its enumerated powers. It's not an independent grant of authority, which is to say it only applies if you start with a legitimate exercise of an enumerated power, which they actually don't have here. But even if they did, as in Raich, I mean, that really was one of the things at issue in Raich, where they clearly had, Congress can clearly deny or exclude certain substances from interstate commerce, which is actually if you back it down to the theory, how is it that Congress can regulate either drugs or adulterated milk or many other things? It's because they can exclude certain things from interstate commerce, and from that, the rest flows. And what the court in Raich and actually Justice Scalia in a concurrence said was, in addition, under the necessary and proper clause, assuming that legitimate exercise of authority, Congress can then also pass laws that will make it effective. And what they mean by that is not make it work. The necessary and proper clause is not a catch-all that basically lets Congress succeed in its goal, whatever that goal has to be. What it means is Congress can do things like make you keep records. Congress can do things like create enforcement mechanisms. It can essentially avoid or keep people from either evading or avoiding or undercutting the law in its enforcement. But it is not a basis for saying that, well, if we need the right to impose the individual mandate or to require people to do something in order to make the scheme that we've adopted work, then we can do that. That is not what the necessary and proper clause says. It's not how it has been interpreted. And even if you actually did accept that, it's not enough to be necessary. It's got to also be proper. And another thing that Justice Scalia pointed out in his Raich concurrence is that that is a real test. When you look at what is proper, you see what it does to the constitutional fabric. And here, what it does is it allows the federal government to exercise a police power and ultimately destroys, when you put that in conjunction with the supremacy clause, it reduces the states to administrative units. And that is not what the Constitution says.
Well, just quickly, status. Do you think the court's decision, if it eliminates, if it takes out the individual mandate, would the decision result in basically the status quo ante before the individual mandate was passed, or do you see an opportunity for a more limited construction of how the Commerce Clause is used by Congress on other issues?
Well, that honestly is hard to say. I think in this instance, they went over what I think is a very bright line, and I think the court will push them back over it. Now, and certainly as a result, hopefully Congress will be a little more careful in the future. Okay, probably not, but we can always hope. Whether it leads to a new understanding of the Commerce Clause or additional restrictions, I'm not sure we can really say, except to say that every time the court affirms that the federal government is one of limited and enumerated powers, it is good for Commerce Clause jurisprudence.
Well, I tell you what.
I wanted to
go ahead,
address
Betsy.
that question for just a second,
Sure.
because in the 11th Circuit Court of Appeals decision, Judges Hull and Dubina, who wrote the majority decision, it was 2-1, explained that by requiring all Americans to be covered, all Americans under age 65, and there are a few other exceptions, to be covered by one of these plans, they used the word over-inclusive. And they took great pains to explain maybe it would be permissible to require those people seeking health care to pay for it with coverage. Right. That, they said, might be plausible. And that was a very interesting comment to me. But of course, there's a difference, they said, between requiring those who are in the health care marketplace to pay for their health care with insurance and forcing people into commerce who are uninvolved, right? That obviously exceeds Congress's authority. So it was interesting that they made that comment, and
Yeah.
I can imagine Congress trying again to somehow require that people who go to the hospital have coverage. That
Sure.
would be different.
It certainly would be different under the Commerce Clause.
Yeah.
Now, at that point, of course, we start talking about other constitutional provisions, and when you start getting into the area of